Judge orders CDC, FDA to restore websites removed after Trump's gender order. A federal judge has ordered the Centers for Disease Control and Prevention, CDC, and the Food and Drug Administration, FDA, to restore several public health websites that were taken offline following an executive order by President Donald Trump. U.S. District Judge John D. Bates granted a temporary restraining order in response to a lawsuit filed by the nonprofit group Doctors for America. The lawsuit challenged the removal of key medical resources, arguing that the decision lacked proper explanation and likely violated federal law. Judge Bates ruled that taking down the websites without justification prevented doctors, researchers, and the public from accessing crucial health data. He ordered the agencies to reinstate the sites immediately. Websites taken down after executive order. The affected websites, some in operation since the 1990s, included resources on HIV monitoring, youth health risks, and assisted reproductive technologies. The Trump administration had ordered federal agencies to recognize only male and female genders and directed them to remove programs related to gender ideology. In response, the Office of Personnel Management instructed agency heads to review content for compliance. Doctors for America argued that the removals exceeded the executive order's scope, calling it a major healthcare nightmare. The organization emphasized that eliminating these resources disrupted public health efforts, making it harder for doctors to treat patients and researchers to study critical health issues. Critical medical information disappears. Some of the removed information was essential for tracking and responding to disease outbreaks. For example, the CDC's Social Vulnerability Index helped identify high-risk communities during the COVID-19 pandemic. The FDA also took down websites that tracked efforts to improve diversity in clinical trials. Doctors for America's attorneys warned that deleting these resources created dangerous gaps in medical knowledge. They cited the Administrative Procedure Act, which requires agencies to follow specific steps when implementing new policies, and the Paperwork Reduction Act, which mandates public access to government information. Government's defense and judges' ruling. The Justice Department defended the removals, arguing that the CDC and FDA were still reviewing content and had not made a final decision. They also claimed that the information remained accessible through private archives, like the Internet Archive's Wayback Machine. However, Judge Bates rejected this argument, noting that relying on an external service was not a valid substitute for official government resources. Doctors directly impacted by the removals testified about the consequences. Dr. Reshma Ramachandran, a Yale School of Medicine professor, explained that the CDC had removed a website providing contraceptive guidance, making it harder for her to advise patients. Dr. Stephanie Liu, who screens patients for HIV, noted that information on HIV prevention and treatment had disappeared, limiting her ability to address a recent outbreak at a local high school. Judge Bates ruled that these actions harmed everyday Americans, particularly underserved communities that rely on accessible medical resources. He criticized the administration's handling of the issue, stating that the government should have kept the websites online while reviewing them instead of abruptly removing them without notice. Ultimately, this ruling is another legal setback for the Trump administration, which has faced multiple court challenges over its executive orders. The CDC and FDA must now restore the removed websites while the lawsuit continues.